To the advisory group's fiduciary responsibility overview and education review to help retirement plan fiduciaries understand and manage their responsibility to reduce liability as well as optimize outcomes for plan participants. We'll cover an array of topics in this session, including what key processes are, what a fiduciary is, who's a fiduciary, some of the typical fiduciary duties and failures, the oversight bodies, and other topics. And a key part of any important activity is understanding the space between things that matter and things that you can control. This applies to fiduciary activities as well. A big part of what matters that you can control has to do with process and key documentation, which is part of a good process. And that will help achieve better outcomes for plan participants as well as manage your time effectively as fiduciaries and reduce liability. Fiduciary responsibility is driven in the retirement plan world for most retirement plans by the Department of Labor and the Securities and Exchange Commission. And two very succinct comments that DOL and SEC representatives, senior professionals, made in the past are do the right thing. So if you are always focused on what the right thing is for plan participants and doing your best to affect that, and focused on securing retirement income, which means doing the steps to help plan participants have enough assets to be able to have sufficient spending money during retirement to meet their needs. If those are the focus, you're on the right track. That doesn't mean you are responsible for ensuring that plan participants have sufficient retirement income, and doing the right thing and acting in the best interest of plan participants doesn't mean that you have to take as much money as possible from your company and put it in the accounts of plan participants. There are limits that are established by your company, but once those limits, for example, a match or other dynamics, are established by the company as a decision, that's separate from the fiduciary decisions. But once those company decisions are made, then within that framework, fiduciaries are expected to help plan participants as best they can. In general, fiduciaries, as a general definition, are those that are entrusted with responsibility for the money or property of someone else, and therefore have the responsibility to act in the best interest of that other party. Fiduciary regulation, rules, and laws are the highest standard within the legal structure in the US because it is critical to act appropriately when you are responsible for someone else's assets. There is a process that is required, but not a specific process, and specific results for retirement plans, for example, are not expected. But using an effective, prudent, proven, effective process leads to better outcomes, lowers liability, and then as you document it, you essentially have proven that you've done your work appropriately as fiduciaries if the process is reasonable and sufficient. There are potentially personal liability for fiduciaries. We'll cover that as well. And again, having the best process is the best insurance policy. In today's presentation, we're going to cover a number of topics with some detailed slides and information. I'm not going to read every word of every slide. We'll be doing an overview, so please hit pause if you'd like to do a more specific review of the nuances of some of these slides, and then we can discuss later separately if you're a client or thinking about being a client. The 5-step fiduciary process is a good example of an outline of what helps ensure that you are following and meeting your fiduciary responsibilities. Analyzing the current position has to do with reviewing and understanding the context of the decisions that you'll be making, the fiduciary responsibility for the different stakeholders, the participants, the demographics, and so forth, to understand and educate yourself in that context as fiduciaries. Step 2 involves creating the optimal investment design. And in many cases, from our perspective, that means building optimal pre-built portfolios or adding pre-built portfolios of some sort that are appropriate to make it easy for plan participants not to make mistakes and to stay on track. And this has to do with, again, understanding the context, the regulations, the demographics of those within the retirement plan, designing those components, understanding the risk return profiles, and so forth. And in some cases, considering tax strategies or tax efficient investing where it might be a taxable retirement plan, such as a deferred comp plan. Then there's step 3, formalizing the policy. This usually involves an investment policy statement to document the high-level decisions and key governance topics, although it's not the same thing as a committee charter, which is more of a governance outline document. But note that neither an investment policy statement nor a committee charter are required. But if an investment policy statement is not present, has not been created, and you're audited by the Department of Labor and they see that you don't have an IPS, that is a sign to the Department of Labor that there is a lack of a process, and they will tend to dig deeper and farther and conduct much greater scrutiny of your process, and which means you're more likely to have a challenging, longer audit and potentially corrections and potentially penalties. Step 4 is implementing the policy. This involves actually taking that menu that's been optimized, or the menu structure, and creating it or implementing it, selecting the appropriate providers to do that, negotiating with those providers where possible and appropriate, and then coordinating, if necessary, the transition of assets from one provider to another if another provider or combination of providers is required, providing the required communications, and so forth. Step 5 is the ongoing step, monitor and supervise. This is where you review the structure, conduct or make sure that the due diligence is conducted on behalf of your committee, typically by an independent third party, financial advisor, consultant, and then rebalance portfolios, reassess needs, reevaluate the demographics, the regulations and other components and dynamics, and then circle back to step 1 when necessary to update as the environment, demographics, regulations, and your philosophy as fiduciaries evolves. There is a prudent process framework that is helpful. It involves the items shown here. Hit pause if you'd like to read all the details, but basically it's about process, it's about diversification, it's about monitoring costs, especially for costs that impact the plan participants. It's also about using experts where necessary if you don't have the internal resources and dedication of time and expertise to make sure that you're meeting your fiduciary responsibilities. There are an array of regulatory frameworks depending on the entity. This shows whether public retirement plans are different than Taft-Hartley plans, which are different than foundation endowments, and corporate retirement plans, as an example, fall under the Department of Labor, the IRS, and the PBGC. This all relates to ERISA, as mentioned before, the Employee Retirement Income Securities Act of 1974. And that act of 1974 regulates fiduciaries, fiduciary conduct, and the key elements to be aware of, in addition to the specifics, is that plan stewardship is an active undertaking. It's expected that you become aware, and ignorance is not a defense, and that you must take steps and use a process and document the process and be thoughtful and deliberative about that process. The history of fiduciary law and dynamics is outlined here in terms of a timeline. Again, you can see here in the middle, 1974 is the biggest update and the most substantial structure relative to most regulatory frameworks for retirement plans. and is also considered a best practice for other regulatory frameworks outside of the retirement plan world where the process might not be as clear. So who is an ERISA fiduciary? It's anyone who has discretionary authority, in other words, control over plan assets or plan management. Anyone who renders or has responsibility to provide investment advice. It could be internally or externally, and for direct or indirect compensation, if the advice relates to plan money or property in the plan. It also includes those that have any discretionary authority related to the administration of the plan. Fiduciary status is, and this is important to know, is based on the activities and functions that actually occur, not just based on a title. So it could be role and responsibility. It could be if you're named fiduciary. It could be if one acknowledges that status, but it also assumes certain activities and functions. And if you are behaving and have the authority and are acting and making decisions that are related to fiduciary responsibilities, and if you're not labeled as such, you are very likely still a fiduciary. Here's an example of what types of individuals or providers are oftentimes considered a fiduciary. So a company board, the plan of the plan sponsor company, trustees, the investment committee for a retirement plan, or yes, those are fiduciaries. Officers of the employee, possibly, depending on their involvement. Investment consultants, very likely, depending on their involvement. Actuaries, attorneys, and auditors or record keepers, generally not, although there may be some exceptions to that, depending on the roles they take on. Investment managers, for example, those that are managing the money within a mutual fund, they are responsible for the money within those mutual funds, but are not responsible for plan decisions or participant level decisions because they are not involved with those decisions. There are a few primary types of plan fiduciaries. 316 has to do with who the plan administrator, the designated plan administrator is. That part of that responsibility can be outsourced, but typically not all of it. And this is essentially those that have some discretionary control. So an important distinction there. 321 fiduciaries are investment advisors that are providing advice and consulting and recommendations for a fee, and then the client makes the ultimate decision about all of those dynamics. That advisor under a 321 engagement does not have the ability to make decisions regarding assets. A 338 fiduciary, however, is an investment advisor who is under that portion of the code also labeled an investment manager, even if we also use the term investment manager for the underlying mutual funds or commingled funds or separate accounts that might be managing subcomponents of a portfolio or individual funds within a line retirement plan menu. However, when it's the advisor, that advisory firm has discretion, but within limits as defined in the investment policy statement. So oftentimes we will refer to this role as semi-discretionary because oftentimes, for example, the advisory group will advise the retirement plan committee regarding what the investment menu should be or what makes the most sense. The investment committee from that plan sponsor makes that decision. That becomes a policy decision, gets documented in the investment policy statement, and then the advisor, in this case, the advisory group, is responsible for implementing that decision. And that's where the actual money decisions begin in terms of the 338 fiduciary advisor organization. Ultimately, it's still the responsibility of the plan sponsor to monitor because the plan sponsor is not able to fully delegate these responsibilities. In a 338 environment, the monitoring becomes more focused on the advisor. Are they fulfilling the role? Are they conducting the due diligence? Are the results reasonable? And the investment advisor will be providing the same type of reports that they would be providing typically under a 321 engagement, but then a little bit of the emphasis and the focus shifts, but the reports help fulfill that responsibility as well. There are also non-fiduciary functions. So to clarify, the business-related decisions are called settler decisions. This is whether or not the organization decides to have a retirement plan, whether or not they decide to close that plan down, the level of plan funding, such as a match, other decisions that are company-level decisions that then become the framework within which the retirement plan fiduciaries conduct their work. There are also ministerial duties. These are activities such as helping enroll employees, helping interact with the record keeper, where decisions are not being made on the behalf of plan participants, but helping make processing decisions or information decisions. But that's an important distinction. So, but someone who is ministerial, if they then are consulted and end up voting around a decision that is directly impacting assets, that can cause them to shift from ministerial to fiduciary status. So for those that are wondering where they are in that status, you want to be careful if you are trying to avoid moving into that fiduciary responsibility zone. There are 4 key duties for plan sponsor fiduciaries. Won't go into all the details here. Hit pause if you'd like to read the details, but at a high level, it's about loyalty, doing the right thing, acting in the best interest of plan participants. The duty of care and prudence. There's an expectation about the level of expertise that you must have if you are acting in the fiduciary capacity. And if you don't have that expertise, you're expected to hire and bring in objective, unbiased expertise that will help you meet your fiduciary responsibility. There's the duty to diversify. This is the requirement to provide sufficient and appropriate investment vehicles to allow a plan participant to create a stock bond mix with a risk profile that meets their needs. There are a number of ways to do that. That's a separate conversation, but that's the key idea there. And then the duty to follow plan documents. The plan document essentially becomes the law of the land within your retirement plan framework. And so plan sponsors must follow their own documents and their own documentation and their own internal rules in that regard. Those documents can be changed if a philosophy or a preference or a goal changes, but you must act within that framework until they are changed. Complying with the duty of care concept involves the idea of how you're behaving, how you're documenting what you're doing. So trustees or other fiduciaries should ensure that they're following a prudent process. Don't assume that you are. If you are a new fiduciary joining a committee, ask for an outline of the process. If it's not easily available, that may be something that the retirement plan advisor can assist with. And ensure that records are available and are documented in terms of decisions in particular. And then it's important to make sure that all important steps were taken to ensure that informed, rational decisions have been made on behalf of plan participants by you as fiduciaries. However, it's also important to avoid over-documentation. Minutes are essentially required because while there's not a specific approach or format to doing minutes, you want to show that you met, show that you discussed and reviewed and the plan, and that there are no significant concerns, or if there are significant concerns, that you are working on it. But for example, what you don't want to do, because this creates what we call a fiduciary trap, is to document all discussions about all concerns, even if they are not substantive concerns. There may be a committee member who is worried about something that is not doesn't turn out to be an issue, but if it's documented and then it's not later documented that that concern was addressed, that can create a liability. The advisory group provides a simple sample minutes format that suggests that type of approach to avoid those fiduciary traps. And that's not to say that you can't also document other questions and concerns and thoughts, but that should be separate from formal minutes, because formal minutes are discoverable in a court of law, whereas general personal notes, so to speak, that aren't reflective of formal documentation and for the plan and the plan sponsor can be noted separately. For this reason, it's also an important consideration and generally currently recommended not to use AI as a note taker for retirement plan committee meetings, nor to record those meetings, because if there are comments that aren't followed up on, that may also be discoverable. And if you record them and then delete them, if there were ever a question and the court said, well, why did you delete them? It may appear that you were trying to hide something. So consult your ERISA attorney around that as note-taking by AI and other sort of recording methods evolve. But in general, we would encourage being conservative in that regard at this time. A key concept, as stated before, is to act solely in the interest of plan participants within the framework and decisions that are made by the settler or the company plan sponsor. And in that regard, if you think about who's being paid for the different responsibilities, settler functions cannot come out of plan assets, cannot be paid by plan participants, because that is a company expense by definition. So that would be considered a conflict to be billing company decisions to plan employees. Administrative services, because they directly serve and benefit and affect plan participants, can be charged to plan participants if you wish, a portion or in their entirety, or not at all. Services that also should not be compensated out of plan assets involve those benefiting the employer, such as the settler functions as mentioned, or a union, which is not directly the plan participant. Services for a different retirement plan relative to a given plan that might be being discussed. So you can have costs that cross over from one plan to another, and so forth. I would also mention that if you have an ERISA attorney, and many people should have one at least ready to go, even if you don't talk or work with them regularly, if you have a relatively low maintenance plan, you want to pay for that outside of the plan, because having plan participants effectively pay for that service can make that service discoverable, and you do want to be able to have open discussions without being concerned about that. Even if you're just educating yourself, you might be brainstorming in a way that could be misconstrued by the court, and if it's discoverable, then that will be visible in court. Typical fiduciary tasks involve appointing the fiduciaries, delegating certain responsibilities, selecting plan providers, determining investment policy, selecting and replacing over time as needed plan investments, providing investment advisory services. That's typically by the investment advisor, approving payment of fees from plan assets, interpreting plan provisions. And in parentheses here, you'll see who the typical organization is that would be responsible for those tasks, but that can vary a little bit by organization in a few of these cases and the way things are structured. There are an array of typical fiduciary failures. Won't read through all of these. Please hit pause and review in detail. What I will say is the most common fiduciary breach is late payroll distribution, arriving late to the retirement plan. And the typical There's not a hard rule that's established by the Department of Labor for this, but what we hear most from ERISA attorneys and plan providers and record keepers in terms of legal cases where there have been problems is typically a 7-day maximum. That if you're less than 7 days, generally you're considered to be safe. That could change over time as electronic mechanisms and software structures improve. If it becomes reasonable and there's a newer, shorter, faster standard, then it could shrink from 7 days to a smaller number. What are prohibited transactions? There are certain types of transactions that should not occur. This couple of examples are if there is a fiduciary for a plan that has a personal interest in the investments, the transaction, so that's a self-dealing provision. If that fiduciary represents something that benefits them in some other way that may negatively impact plan participants, that's a conflict of interest component or provision. And anyone who there's a transaction that's specifically where the fiduciary receives some sort of compensation for that, again, oftentimes referred to as a kickback, and falls in that, also in that conflict of interest category. More on prohibited transactions shown here. There's a more recent term called party in interest, and there are an array of or expansion of examples of what types of people or parties might be involved, where there's some sort of sale, exchange of goods or services or payment that benefits those that are directly or indirectly involved with the plan at the expense or detriment of plan participants. There are also some transactions that have special exemptions. For example, a participant loan, which might, under the prior definition, be considered a prohibited transaction, is not, because it's an allowed decision of a plan participant to borrow from their own account. And other examples are shown here as well. There are penalties where prohibitive transactions occur and are discovered. Civil monetary penalties, oftentimes up to 5% of the amount involved, especially, or if not subject to an excise tax, plus an IRS penalty, which could involve the 15% excise tax. That can be increased to 100% if it's not corrected on a timely basis, and there can be risk of disqualification of the plan's tax status. Key liability concept for plan fiduciaries regarding personal liability are important to be aware of. Many fiduciaries are not aware that they can have individual personal liability. So for example, for plan losses, if fiduciary rules have been violated. So personal liability can occur if a plan fiduciary is aware of another concealing a breach, another fiduciary concealing a breach, if their own breach was enabled or enabled another fiduciary to conduct a breach, or if a fiduciary is aware of the breach of another fiduciary and doesn't make an effort, a significant or sufficient effort to stop it and cure it. This type of liability can increase when you as fiduciaries don't have a clear process, because then it's not always clear exactly where the process begins and ends and where a breach may begin and end. Whereas if you have a clear process, even if the Department of Labor may feel very clear about what's a breach, If you are not clear about what it is, you might slip inadvertently into a breach zone without being aware, having the education, having the process in place. There's a concept called co-fiduciary liability, and this is where even if there's another fiduciary that has a breach and you are aware of something, that breach, but you do nothing. This relates to a comment a moment ago, but it creates a co-liability for both of those parties, not just for the party or fiduciary that specifically created that breach. You can have co-fiduciary liability if you should have known of a co-fiduciary breach, even if you were not aware, because there is a responsibility to monitor and be aware of each other and the overall process you are using and how each of you as fiduciaries are acting and interacting in that process. And of course, if you fail to perform your own fiduciary duties and in that process are enabling or affecting a breach. It's also important to note that if there is a breach and the fiduciary resigns, that does not absolve that co-fiduciary the liability. Again, ignorance is not protection. Once there's a breach, it stays until it is addressed appropriately. Ways to reduce this type of responsibility or liability involve, at the highest level, using a process, delegating certain responsibilities where you don't have expertise and are incapable of effecting or conducting the right decisions or process just by the nature of time availability or lack of expertise. The employer may, to some extent as well, indemnify fiduciaries, so you can have an indemnification letter, something to explore with your ERISA attorney. You can purchase fiduciary liability insurance as an additional layer of protection. And again, to repeat over and over, a good process and documentation and following it is oftentimes the very best insurance policy of all. So who are the regulatory bodies that oversee most retirement plans? Those that are ERISA plans, as mentioned early in the presentation, these are the IRS and the DOL, the Internal Revenue Service and the Department of Labor, each of whom have responsibility for monitoring and enforcing the regulations and oversight of the different retirement plan fiduciary responsibilities, many of which are listed right here. So please hit pause if you'd like to review them individually. Documentation, as mentioned, is critical. There are some documents that are required, some that are not required, but that are recommended. So some that are critical are keeping permanent plan records, plan documents, summary plan descriptions if you have one. Also, as a side note, case law shows that if your summary plan description does not match your plan document, even though it's expected or intends to be a summarized equivalent of your plan document, oftentimes the court will rule in favor of whatever is, if they state two different things, whichever language is more advantageous to the plan participant is usually what will hold. So if you use an SPD, make sure it is carefully written, carefully crafted. And for that reason, some ERISA attorneys we hear discourage having plan documents or SPDs translated into foreign languages because it requires that the translator have sufficient expertise to ensure that it is a perfect match in the two languages, and that can otherwise you can create an unintended and somewhat invisible liability there. Other evaluation reports and records, plan health reports, and investment advisor due diligence reports. These are all things that should be reviewed and documented to show that you have been sufficiently fulfilling your fiduciary responsibilities. Governance documents, as mentioned before, the committee charter and the IPS are not requirements, but are generally recommended. Highly recommend the investment policy statement because it is important for clarity and there's a red flag to the Department of Labor if you don't have one. Committee charter can be surprisingly helpful and can be very simple. We also have a sample outline that we've created a number of years back through the help of an attorney to give you a starting point if you want to work on that with yourself, review what that might be and work with your ERISA attorney to fill that out or update it or customize it to your own needs. Meeting minutes we've already discussed, important, and are essentially what proves or shows that if they are done right, that you've fulfilled much of your responsibility. But again, you want to do that in a way that doesn't create fiduciary traps. There are also other policy documents that you may wish to include, such as fee policy documents or mutual fund revenue sharing policy documents, which sometimes are inside a fee policy document, just so there's clarity internally and documentation so that you know how what your decisions are around that, rather than defaulting to some standard that you might not even be aware of. Of course, you also want to have documents of service agreements so that you can reference that, and because those service providers are providing tools and resources to plan participants, and especially to the extent that any of those fees are charged to plan participants, you should be especially thoughtful about documenting and being aware of what the fees are and how they are being charged and to whom. There are other communications that are important and sometimes required. Safe harbor notices are required. Qualified default investment alternative notices are required. Fee disclosures are required. Blackout notices are required. Interestingly, you'll see that plan participant education, while a communication type, is not actually a requirement, but it is highly recommended as a way to help plan participants make better decisions. One decision that fiduciaries can make is regarding their intention to fulfill the 404C requirements. If you fulfill those requirements, it lowers fiduciary liability for self-directed plans if done properly. And what 404C, the section of 404C within ERISA says that if the investment menu includes a sufficient number of portfolios that enable plan participants to either build or select portfolios that allow them to be at different places along the risk return spectrum to meet their own needs, then fiduciaries are not liable for losses. So this is a key opportunity, very easy to do, especially if you're using pre-built portfolios like target date funds or target allocation funds. However, if any funds or pre-built portfolios that are put into the plan, they still need to be built reasonably. Fiduciaries can still be liable if those funds are poorly constructed or consistently or dramatically underperform without a defensible reason, and or have excessively high fees that plan participants pay. And there is case law around this, but it's fairly easy to avoid those problems with a reasonably built or selected portfolio or combination of portfolios. It's key to note here that when this language was originally created for 404C, this could have meant, or really intended to mean, 3 individual asset class funds, mutual funds, for example, that would allow a plan participant to build a reasonably diversified portfolio. But now, with the increasing utilization of target allocation funds and even more target date funds, having 3 of those along the risk return spectrum essentially creates much more assurance that you're meeting the 404C requirement. And naturally, with target date funds, it's typically 14, 15, 16, 17 funds, depending on the plan and demographics. And for target allocation funds, we typically see 4 static portfolios along the risk return spectrum. As a quick review, in terms of fiduciary, not so much liability and responsibility, but having a certain sufficient education and understanding of basic investment knowledge and dynamics is critical to understanding why a portfolio is a combination of portfolios should generally be offered in a plan, and therefore helps you understand your decision making and justify that. So the basic idea around the what's called the efficient frontier is that if you have an array of individual asset classes, such as the colored dots here, the non-gold dots, and you combine them in certain ways, you're able to increase return for a given level of risk or decrease risk for a given level of return. So that's called portfolio optimization. And this is also why we generally recommend using pre-built portfolios that are designed in such a way that they fall along the optimized efficient frontier. Whereas if you just offer or also offer an array of individual asset class funds, plan participants are responsible for creating their own portfolio. And from what we've seen historically and what some research shows, that the plan participants are not as effective at building their own portfolio as professional investment organizations are. Once you've built the portfolio, then it's important that you be aware if you are doing this yourself, or more likely and much more commonly because of a lack of expertise and time and resources on the investment committee of a plan sponsor, having an advisor, an independent advisor, have a reasonable, effective, and prudent process for selecting those underlying investments within the plan, whether they are individual asset class funds or individual asset class funds that are used then to be components within a pre-built portfolio, such as a target allocation or target date fund. So the best processes tend to involve both qualitative screening and quantitative screening, a human overlay of research and knowledge to vet those organizations regarding people, process, philosophy, and so forth, a more specific investment committee, either at the advisor's end within the advisory firm and the plan sponsor end, to then make some of those final decisions. And then that would, who makes that decision would depend on whether or not it is a 321 or 338 engagement with the advisor. And then the final selection, which again depends on whether it's 321 or 338. So as key takeaways, the very highest level, you can print this out, fold it up, put it in your pocket if you're a fiduciary, look at it every once in a while. The key thing is to do the right thing, use best practices, and document the prudent process without over documenting in a way that can create unnecessary liability. Fiduciary responsibilities relate to doing the right thing, best interest focus related to plan participants, having a committee, having that committee be responsible and involved and sufficiently process driven and informed with guidance, typically from an investment advisor. Understanding that responsibility, this presentation is designed to give you at least a high level framework of that, and then work with your advisor or your ERISA attorney and/or your record keeper and third-party administrator to address and understand any specific details as they come up or as regulations change, and clarify the duties of the committee, hire experts to fulfill those roles, use that prudent process, document that process, and then confirm compliance and have a process around compliance as well in terms of your Form 5500 filing, documentation, transferring of contributions through the payroll provider to the record keeper, and so forth. And the advisory group and our process approach, the 5-step process we outlined before, is an example of something that is specifically designed to address all of the primary fiduciary responsibility areas. It doesn't, by definition, make you compliant as a fiduciary, because you, as fiduciaries, must take your own action and follow your own process and actually follow those steps and have the discussions and follow through as appropriate. But that's the structure that the advisor group provides starts with the philosophy of putting plan participants first, using an effective, documented, clear, institutional style process, educating both fiduciaries as well as plan participants, and then staying current on your behalf regarding updated best practices that we can bring back to you and help you implement, and combine that with our decades of experience and relative to your specific demographic and company culture needs. And as part of that, as mentioned as we went along here, there are sample documents that we're able to provide that will help you fulfill those needs if your ERISA attorney is not already helping you do that. There are other topics that are not covered by this presentation that are helpful for fiduciaries. We conduct quarterly context presentations and recorded webinars. You can find those on our blog. Those are helpful in terms of ongoing context for markets, economy, investor behavior, high-level major regulatory updates, in addition to maybe the details that your ERISA attorney might provide. You may wish to dig deeper with investment concepts to understand better. You can work with your advisor to do that. Callan College is one way to go deeper in some areas. We have access to that for clients. There's a separate fee the clients pay if they want to attend those sessions. There's the governance and committee charter documents that we have referenced, but merit exploration if that's a new concept or something you haven't done. You are also responsible for ensuring that there's sufficient cybersecurity as technology evolves, and that typically involves you interacting with the record keeper to make sure that that's sufficient. And then, of course, if you are at a nonprofit or have a nonprofit element connected to your for-profit business and have some sort of endowment type structure or other corporate asset fund, there are rules and opportunities to optimize there. So that's a whole separate fiduciary category and education to explore separately. So thank you for attending this session and listening. If you have questions, please contact your advisor at the advisory group, or if you're not currently or yet a client, feel free to reach out and we'd be happy to be helpful. And thank you for what you do as fiduciaries and your important impact on the lives of many people and helping them become retirement ready and improving their quality of life as a result.